Good afternoon. This is the long-awaited briefing on student rights and restrictions due to a multitude of technical difficulties, but here we go. So the overarching theme with student rights and restrictions have to do with due process and ensuring that schools have the right documentation in place as far as restrictions go. Student rights, their rights do not end whenever a student enters the door, so it's a fine line to be considered, and one that must be tread carefully, is still under heavy debate today. The school has a duty to prevent suspension and expulsion. Every student has a right to a free and public education. With this free and public education, it is our job to try to know our student rights and to know our rights and what we can do, as well as restrict students so they don't interfere with others, like other staff members and student rights as well. But in the end, the overarching theme along with is that a student has a right to a free and public education. Students are going to misbehave, and it's our responsibility to teach them. While we're trying to prevent any damage from occurring, it is important that students ask and make some mistakes, but we can correct them before they become a large issue, and to teach those students of what those instances are. We must have a clear process to mitigate this behavior with multiple different strategies. We're trying to keep kids in school. We're trying to keep kids in class and learning. They're going to do much better in this type of environment than in an alternative education situation. It's also important that all staff has regular contact with students, must have professional development to learn skills and strategies for classroom management and conflict resolution. Again, we are trying to keep all of our kids that have that right to the free and public education in the classroom where we can best service them. All of these strategies must be in place well beforehand as a preventative measure. We don't want to respond to something that hasn't been predicted if we can possibly do so and plan for these measures ahead of time. That is with the different programs that are in place to keep a kid into school, therapies, different alternative or placement strategies, and teaching them about their social and emotional learning. School staff are also required to make a referral for special education evaluation when they reasonably believe a student's continued inappropriate behavior may stem from a disability. If we disregard these measures to provide the students with provide services to a student with behavioral disability, the student may challenge the school's decision to impose, and they would have the right to do so. This is part of due process. Grounds for suspension and expulsion. A student may be suspended or expelled for good cause, which includes but is not limited to any of the following conduct. That is, continued disobedience, defiance of authority, stealing, damaging of school property, occupying or causing others to occupy the building without permission, otherwise trespassing, causing the students to skip school, possessing, using, or being under the influence of illegal drugs and alcohol in the building or on grounds, harassment, intimidation, or bullying, trying to injure or injuring another student, teacher, or someone who works for the school or school board member, conviction or adjudication of delinquency for possessing a gun, committing a crime while armed with a gun or a school property, bus, or other school function, knowingly possessing a gun on school property. We are required to provide sufficient notice before any of these proceedings. The student must know, and the student's parents must know, what is going on beforehand with an attempt to mitigate these before they become such a problem where they require suspension or expulsion. Basic principles of due process as well as provisions of the state discipline code. However, we require at a minimum the notice of offenses that could lead to exclusion from a school. Your proper communication is key. We must ensure that the parents and the student of the parents, the student of the parents are well aware of what proceedings are going on, why they happened, and what has been done to do or to try to prevent it, as well as our responses we intend to take. We cannot expel unless we have met all the requirements of due process and applied alternative education. Many court cases do get caught, or many school cases get tossed because we did not follow due process. The distinctions between suspension and expulsion. Legally, these two are quite different, but due process is right we cannot deny. As far as suspensions go, a short-term suspension is less than 10 days, and needless to say, long-term suspension is more than 10 days. And expulsion is a discontinuation of educational services altogether. While a student is suspended, we are still required to give them the educational services that they require in an alternative format. Suspensions can be imposed in school or out of school, and students maintain the same rights in any procedure due to the limitation of attending class, because we are excluding them from the free and public education in some manner. All procedures must be presented to the student so a thorough understanding of what's going to happen is understood. Requirements for a suspension of 10 days or less. The Due Process Clause of the 14th Amendment to the U.S. Constitution has been interpreted to require the provision of the following procedural protections to a student facing short-term suspension. 1. An oral or written notice of what the student is accused of doing and the factual basis of the accusation. In the school that I am running, we will be doing this as a written notice and written notice only. Or oral notification is easily contested and difficult to prove. I'm not trying to second guess anything of this nature if we have to go to this extent, especially where legal could be involved. An explanation of the evidence on which the charges are based if the student denies these charges. We must have proof, in one way or another. It might be witness testimony with a sworn statement, or with physical evidence if proven necessary, or available. 3 is an informal hearing or meeting with the superintendent, principal, or other school administration before the student is removed from school, during which time the student has an opportunity to explain that student's side of the story and request a leniency in punishment. Every student has the opportunity to defend themselves or explain themselves. There might be more to the story than what we understand, and from us, it is difficult for us to interpret occasionally, depending on what's going on. You only get one side of the story from one student, and oftentimes we are not there to personally witness what has occurred. This is our chance, or the student's chance, to offer rebuttal and possibly not punish somebody who's innocent, should they be able to prove it. Procedures required for long-term suspension or expulsion. The board is the only entity permitted to impose a long-term suspension. Student services must continue within 5 days of suspension, and the following procedural protects are required. Prior to removal from the school, all procedural protections provided to the student are facing short-term suspension unless the student causes a serious disruption or presents a danger to themselves or others. Usually this is a case of repeated offenses of a minor offense that adds up over time and the severity of which must be consulted, or, as it said, the seriousness of disruption, where a student, say, activates a bomb threat and causes disruption to the entire school where they could continue this behavior. We need to stop that before it disrupts the school any farther. 2 is an immediate notification of parents with appropriate supervision until the parents arrive. If we are considering this on a short-term basis, there is absolutely no circumstance for that student should be with the general population until parents arrived and this begins to resolve. Within 2 school days of the suspension, written notice to the parents that includes specific charges, facts, and the student's due process rights. A continuation statement must be sent to the parents as well, stating that the school intends to expel or long-term suspend. A formal hearing is to be held before the local Board of Education within 30 calendar days. And this is where part of our documentation comes in, that we need to make sure we're dating and putting the appropriate numbers down as we're documenting these, so we don't accidentally throw ourselves out over something that we can prevent. The board must provide, no later than 5 days prior to the formal hearing, a list of witnesses who will appear against the student at the hearing, as well as a statement or affidavit containing the facts to which the witnesses will testify. Information on the student's right to bring an attorney to a hearing and legal resources are available within the community. A manifestation determining for a student with a disability. At the hearing, the student must be given the opportunity to defend themselves by explaining their side of the story, present witnesses to testify on their behalf, present signed statements by witnesses on his or her behalf, and face questioning from witnesses from the school district whenever there is a question of effect. Very similar to a courtroom, due process is not that much different within a school hearing. The school board must receive and consider the entire report before coming to a decision. And the decision must at minimum be based on a preponderance of the competent and credible evidence and must prove a more than likely situation. So if the student most likely did this, then it will be decided upon. It does not need to be proven to the extent that criminal law is within a standard courtroom. Within 5 days, the parents must receive in writing the statement of the board's decisions. They should not decide until after they have all the facts, but they still have a limited time to decide what their decision will be. A student that has not received all these steps cannot be legally expelled without total due process. It is important that we do not skip a step or misdocument any of these steps as we go, as it will likely be thrown out, with other potential legal repercussions. Discipline rules for assault. There's 3 distinct offenses when regarding assault in a school. There's assault against personnel or a school board member, assault with a weapon against said people, and possession of a firearm or any school-related property. The student that commits these must be afforded all the same due process procedures as a long-term suspension with these additions on top. The school must immediately suspend the student from the school until the school board holds a formal hearing. A 1-year removal for guns under the Zero Tolerance for Guns Act. This student will not be allowed to attend school any further, and this is considered a long-term suspension. The student will have the opportunity, depending on and pending criminal charges, the following school year. A return to regular education program following the suspension or removal for a student who committed an assault. We must have a program in place for reintegrating the student and continuing their education, as the student still has a right to a free and public education and included in the general population. Discipline for behavior off school grounds. Schools can prohibit conduct off school grounds only if it is reasonably necessary for physical or emotional safety, security, and well-being. We're all aware of what students are capable of regarding cyberbullying, and this is needed to prevent that and educate our students as well with the effects that cyberbullying can have on other students. The conduct materially and substantially interferes with requirements of appropriate discipline and the operation of school. Due process rights related to the discipline of behavior off school grounds are the same as other disciplinary actions. And what boils down to this is there must be an interference of student rights. whether it's the right to a free and public education or the individual student's rights as far as not being harassed within school and other bullying type offenses. One that is really a problem in our area here is removal from school due to suspected substance abuse. We have local board policies as well as state that we must follow with this. In accordance to federal regulations, all school districts must protect the confidentiality of the students. This is not public knowledge. Overall, the state statute and regulations relating to substance abuse are aimed at prevention and intervention services to support and help a student with a substance abuse problem. Again, overarching theme is the right to a student's free and public education. Schools are largely regarded as a safe space for students and should be that way. Should be a welcoming and warm environment for a student to willingly and want to come and learn at any given point. This includes helping out with the healing process of substance abuse. These policies and procedures must contain due process requirements and provide sanctions graded according to the severity. Part of this will have to do with how local law enforcement deals with substance abuse after we have made the appropriate reporting. Removal from school and medical examination. State law mandates the removal and medical examination of a student suspected of being currently under the influence of alcohol, controlled dangerous substances, and any intoxicating chemicals. The examination may be conducted by the school physician or a doctor selected by the parents. If the parents choose to select their own doctor, they are financially responsible for those doctors' bills incurred. Within 24 hours of the examination, a physician is required to issue a written report of his or her findings to the parents of the student, the principal, and the district's chief school administrator. Search and seizure. The law governing student search and seizure is complex and constantly evolving. The following is a summary of the general principles. All search and seizure must be based on reasonable suspicion. Reasonable suspicion means that there is substantial behavior or evidence that proves that the student might have something as far as a weapon or substance abuse materials. Searches are conducted in an appropriate manner, and that the search was reasonable given its scope, duration, and intensity. Meaning, if we suspect a student of having a small amount of some type of drug paraphernalia, that is not necessary to strip search a student. And in fact, that is something that is done under extreme duress. It will never be conducted at this school without local law enforcement helping to guide us as well as legal. A search by school officials will be reasonable in its scope and intensity when it's reasonably related to the objectives of the search. It is not excessively intrusive in light of age and gender of the student and the nature of the suspected infraction. Suspicionless searches, in contrast to searches of specific individuals or locations, general suspicionless searches are targeted against an identifiable group of students and are usually looking for one or two specific things. Referral to law enforcement. School staff has reason to believe a student has unlawfully possessed or in any way involved in distribution of a controlled dangerous substance. We can refer to law enforcement. School staff has reason to believe